नमस्कार दोस्तों, आपका स्वागत है योगेश महाजन लीगल चैनल पर। योगेश महाजन लीगल चैनल पर हम आपको प्रस्तुत करेंगे नवीनतम सुप्रीम कोर्ट के फैसलों और विभिन्न अन्य न्यायालयों के फैसलों पर और विधि ज्ञान को प्रसारित करने का प्रयास करेंगे। इस चैनल पर हम न्यायिक फैसलों के महत्व को समझाने और विधि समझौतों की युक्तियों को समझाने का प्रयास करते हैं। हमारा मकसद है कानून और न्याय के क्षेत्र में ज्ञान को आपके पास पहुंचाना, तो कृपया हमारे चैनल को सब्सक्राइब करें, घंटी आइकन दबाएं, वीडियो को लाइक और शेयर करें।
Friends, on 27th of January 2024, Honorable Supreme Court has pronounced a judgment in which there is a case there between the appellant versus the state of Haryana. And this is the criminal appeal number 2351 of 2011. And in this case, the appellant has challenged the Honorable High Court order, and judgment, which has confirmed the conviction passed by the Session Court. And now what the Honorable Supreme Court has given the decision, let's come to the contents of the judgment. And this is a judgment in which the appellant is an accused, along with another accused, number 1, who were convicted of the offences punishable under 302 of Indian Penal Code and Section 25 of the Arms Act, and both of the accused were ordered to undergo imprisonment for the offence under Section 302 of Indian Penal Code. And since the conviction has been confirmed by the Honorable High Court, so the facts of this case is that on 3rd of January 2004, deceased went to the Rohini to meet his sister, and PW2 is the prosecution witness. He is the brother as well as the complainant. PW2 is the brother of the deceased, and as per the version of the complainant, the deceased has fallen into the bad company, and some cases of the dacoity and theft were registered against him. And he, as per his version, that on 4th January 2004, he inquired with his sister, who told him that deceased has returned after meeting her. So on next day, at around 5 January 2004 at 9 AM, so he got an information that someone has killed his brother, means by the through bullet, means through gunshot. And thereafter, the bodies of both the deceased were recovered, were found by the police. So the case was registered against the appellants, and now prosecution has examined nearly 20 witnesses. And the prosecution case stands solely on the two main witnesses, PW1 and PW3. Both were the eyewitnesses, and PW2, who is the brother of the deceased, he was also examined. And other material witnesses are PW15, who is the inspector, sub-inspector, and PW20 is the DSP, who at that time was the investigating officer. And both witnesses are relevant on the issue of the recovery of the weapon of the offence at the appellant instance. And there was no independent witnesses for the recovery. And this was the case of the prosecution that report of the ballistic expert shows that bullets which were recovered from the body of the deceased were shot from country-made pistols. And now when the case was being heard before this Honorable Supreme Court of India, the learned amicus curiae was appointed on the side of the prosecution, and he made the submissions that the prosecution case was not based on the eyewitness, on the circumstantial evidences, but was solely based on the eyewitnesses who turned into hostile. Both of the witnesses, PW1 and PW3, were turned into hostile. And he made a further submission that in the absence of the independent witnesses, the recovery of the alleged murder weapon at the instance of the appellant cannot be relied upon it. And moreover, further he made a submission that recovery was also placed in the open place, and which was accessible to all. And he further pointed out that prosecution witness number 2, who is the brother, he was on the amicable terms with another person named. He suspected that that individual might have killed his brother and the other deceased, or he may have murdered someone through someone at his own instance. Now pointing towards the testimony of PW20, who is that DSP, and he made a submissions when he appeared in the examination chief, and he has admitted that no examination investigation was carried out about the involvement of the name of the individual which was named by the PW2. So then he further made a submissions that the learned counsel made a submissions that prosecution here in this case fails to prove the story beyond the reasonable doubt. So appellant needs to be acquitted from all charges. And similarly, the contentions or submissions were also made from the side of the state, and they made a submissions then since the recovery has already been made out at the instance of the appellant, and so she also relied upon certain judgments. After hearing from the both sides, the court has made their version that prosecution story in the case is not based on the circumstantial evidences, it's based on the evidences of the eyewitnesses. PW1 and PW3 were the eyewitnesses, and the recovery of the alleged weapon were made at the instances of the appellant, and it was the appellant who disclosed the place who has thrown the dead bodies. And now when they made a comparison, when they made the analysis of the testimonies of PW1 and PW3, the court found that PW1-3 supports the prosecution, and it remains to be considered only the evidence of the alleged weapon of the instance of the appellant. As per the prosecution case, the offense took place on evening of the 4th January 2004 and before 9 a.m. on 5th of January 2004. And as per the version of PW15, who is the inspector, PW20, who is the DSP, he made a submissions that is the appellant made a disclosure statement on 9th February 2004. As comparing the statements, now court has found that both the witnesses, according to both the witnesses, the appellant disclosed that he made the country-made pistols with 2 cartridges wrapped in the polythene bags in the front of the plaza building. And though PW15 has deposed that appellant disclosed the country-made pistol along with 2 cartridges wrapped in the polythene bag were kept underneath the earth in the eastern corner of the open space. And when the court has found that it's the PW20 who did not even specifically depose that appellant discloses the articles were kept under the underneath the ground. So this was the statement which courts found is very much suspectable. It's doubtful that during the examination in chief, it's the responsibility of the PW20 to make disclosures, to make the statement correctly, and he has to state it specifically that it's the appellant who has disclosed the articles and were kept inside the underneath the ground. And PW15 described how the police took the how appellant took the police to the park in the front of the plaza building. And when in the examination chief, he has not even stated that the recovery was made after the digging the earth. This was a crucial statement which the court found that there was a significant omissions there from the side of the prosecution witness 15, who is the sub-inspector there, who is the prosecution witness. And he further stated that the appellant led the police to the eastern corner of place and showed the country-made pistol of 315 bore along with 2 cartridges. Even PW20 in his examination chief does not disclose that recovery was made after digging. Now court again found that there was also a significant omission not with the respect of the PW15 but also with the PW20. So both police witnesses had made a significant omission. They ought have to disclose it, but they did not disclose it, that it was the appellant, that the recovery was made after the digging. And apart from this, memorandum Panchanama of the recovery recorded that the weapon was recovered after the digging. Both P15 and PW20 have not deposed to that effect. Both police witnesses initially state that there was no witnesses available. And when PW20 was cross-examined, and now he has made this statement, they were the public witnesses. In the examination chief, they have not even stated that there was public witnesses were not available. When he was cross-examined, then he says that there were the public witnesses, and they were the public witnesses who were not the interested witnesses. And now court found more than one factors render the prosecution's theories. The court found that the prosecution's story was very suspicious and doubtful. First factor is that recovery was made after 1 month and 4 days. Secondly, recovery was made in the open garden. Thirdly, the prosecution witness of 15 or 20 means sub-inspector and DSP neither have stated that weapons and the cartilages were buried under the ground and recovery were made only after the digging. Fourthly, that independent witnesses were available, but they were not made as the independent witnesses to the Panchanama. So, recovery of the weapon at the appellant's instances thus cannot be believed. The decisions relied upon the learned counsel of the respondent is not significant at all. So there were so many lapses are there in this testimony. And apart from this, prosecution's case was there that on 9 February 2004, it's the appellant who took the police party to a place where he kept the dead bodies. And now, when court has found that recovery of the dead bodies were made, bodies were recovered, were known to the police long before the 9th of February 2004. So it can't be said that discovery of the appellant of the place where dead bodies were kept. So the statement of the accused, this was a part of the statement of the accused, which shows that he would show the place where he has thrown the dead body is not admissible under section 27 of the Indian Evidence Act. So apart from this, PW22 has also named the person who has some inimical relationships, and police has did not even carried out any investigation to find out the role of that person which was named by the PW2 in his testimony. So this police court has found there was significant omissions were there. Investigation was not being done in a right manner. A recovery of the weapon was not done in the presence of any independent witnesses or testimony of the PW15 and PW20. There was significant omissions. Both the police witness has not even stated that recovery was made after the digging. So after and made a detailed analysis, the court found there was the benefit of doubt. From the above reasons, the court found the recovery of the weapon of the instance of the appellant cannot be acceptable as a reliable. So the benefit of the doubt needs to be extended to the appellant. So, but considering all aspects, the court has made the decision that the judgment and the order of the division of the High Court needs to be set aside, and the order passed by the Session Court also needs to be quashed out. So, appellant is appeal of the appellant is allowed, and he has been set into the liberty unless if his enrollment is not required in any other case. So this was a judgment which came on 25th of January 2024.
उम्मीद है कि यह वीडियो आपको पसंद आया होगा। अगर आपने अभी तक हमारे चैनल को सब्सक्राइब नहीं किया है तो कृपया इसे सब्सक्राइब कर ले और बेल आइकन दबाकर नोटिफिकेशन प्राप्त करें ताकि आप हमारे नए वीडियो से अपडेट रह सकें। अगर आपको यह वीडियो पसंद आया हो तो कृपया लाइक करें और अपने दोस्तों के साथ शेयर करें। हमारे चैनल पर आपको न्यायिक मुद्दों, कानूनी सलाह और कानूनी अपडेट्स के बारे में नवाचारिक और महत्वपूर्ण जानकारी मिलेगी। हमारे साथ बने रहें, क्योंकि योगेश महाजन लीगल आपके कानूनी सवालों का सहायक है।